Hey AP Government class, we have two more cases to go over, Marbury versus Madison and Roe versus Wade. So let's start off with Marbury versus Madison. So Marbury versus Madison is probably the most famous Supreme Court case in history, mainly because it established this idea of judicial review. So a little background of the case. The president at the time was John Adams. He was a Federalist. Federalists believed in a stronger central government that was more business-oriented, more manufacturing. In the election of 1800, John Adams, the Federalist, lost to Thomas Jefferson, who was what they used to call a Democratic Republican, which gets kind of confusing because today our two main parties are Democrats and Republicans. But there used to be a political party called the Democratic Republicans. The Democratic Republicans believed in a smaller central government and a more agricultural or farming-based economy. So there are a lot of differences in opinions between the Federalists and the Democratic Republicans. So when John Adams lost the election, the strategy of the Federalists was, since they were going to lose control of the executive branch, they wanted to try to maintain control of the legislature. And they figured they also had an opportunity, because they had the numbers in Congress, to pass laws that would tighten their grip over the judicial branch. And they figured the best way they could do that was by creating a law, because Congress has the power to create laws that expand the size of our federal court system and also create new positions within those courts. So 2 days before Thomas Jefferson was going to be inaugurated as the new president, John Adams scrambled, and after Congress had just passed this law, the Judiciary Act of 1801, John Adams spent his final hours in office appointing all of these members, mainly to the circuit courts. And all these members were Federalist in their political beliefs. They were loyal to the Federalist Party. So this would tighten the grip of the Federalists over the judicial branch. And once again, this was mainly because they were going to lose the executive branch with Thomas Jefferson coming in as a Democratic Republican. So he wrote up all these commissions that would have to be delivered to the judges before they could accept them. Most of the commissions were sent out, but because John Adams did this at the last minute, they didn't have time to mail out every single commission inviting these prospective judges to these new positions. So there were a couple that didn't get sent out. One of them was William Marbury's. So Thomas Jefferson comes into office. Marbury's commission and a couple of others had not been delivered. The process for this would be that the Secretary of State would deliver the commissions to invite these appointees to their new judgeship positions. Thomas Jefferson tells his Secretary of State, James Madison, don't deliver any remaining commissions. Marbury, knowing that he had a commission waiting for him, he wanted to start his new job in the circuit courts, brings his case to the Supreme Court saying, hey, James Madison as the new Secretary of State didn't deliver my commission. So the key questions here were, was Madison's refusal to deliver these commissions illegal? And also, Marbury was claiming that based on this pre-existing law, the Judiciary Act of 1789, it said in that law that the Supreme Court has the power to force the delivery of commissions by something called a writ of mandamus. So the question here was, did the Supreme Court actually have that power? And was this within the Supreme Court's jurisdiction? Did they have the power to rule over this particular type of case, as the Judiciary Act of 1789 stated? So the ruling here is kind of confusing, because the Supreme Court says, yes, Madison was supposed to deliver the commissions, so his decision not to deliver them was illegal. But the Supreme Court at the same time says we are not going to force, by writ of mandamus, we are not going to force Secretary of State James Madison to deliver the commissions. And the reason for that is because when the Supreme Court went back and looked at the Judiciary Act of 1789, this law did give the Supreme Court the power of writ of mandamus in the case. And according to the Supreme Court, this was a violation of Article 3 of the Constitution, which created the judicial branch. The Supreme Court argued this gives us way too much power. It's beyond the scope of power mentioned in the Constitution, that the Supreme Court should not have the power to order somebody to deliver these commissions. So essentially, the court says this case was not within our jurisdiction. We didn't even have the power to hear this or to file the writ of mandamus, meaning the Judiciary Act of 1789, which gave us this power, is unconstitutional. We are overturning that part of the law. And what this does, which is extremely significant, and why this is the most famous Supreme Court case in history, is it establishes this power of judicial review, in which the Supreme Court has the power to look at laws and decide whether or not they violate the Constitution. And if they do violate the Constitution, the court can decide to remove the laws and make them null and void so they no longer have to be followed. And this is also the first time, because it's just being established in this case, it's the first time the Supreme Court exercises the power of judicial review. So this starts a precedent that the Supreme Court can review laws and decide whether or not they're constitutional. And now we know to this day that this is the most important power of the court system, and especially the Supreme Court, is to use judicial review. And that's Marbury versus Madison. So I saved the most controversial one for last. We're going to go over Roe versus Wade. Probably the most noteworthy Supreme Court ruling, at least of roughly the last 50 years, if not longer. And it's still something that's being debated to this day, and we're probably going to see the main issue here of abortion go back to the Supreme Court within the next few years, because there's a few major legal challenges right now to this ruling. So right there you have Norma McCorvey, who was known as Jane Roe at the time. She wanted to keep her identity anonymous because, well, a lot of people were very against abortion. A lot of people today are very against abortion, and to go out in public at this time could have been kind of dangerous for her as someone who is trying to fight for abortion rights, or as we would say, pro-choice. So the background. When Norma McCorvey, or Jane Roe, was 21 years old, she tried to get an abortion in her state of Texas. The problem was Texas outlawed abortions unless they were absolutely necessary to save the life of the mother, and there's some kind of health condition that would cause the mother to possibly die if she went through the full-term pregnancy. That's the only way that Texas would legalize the abortion. She had also initially lied about being raped in an attempt to obtain a legal abortion. Apparently, she wasn't totally clear on the laws in the state of Texas. There were some states where you could get an abortion if you could prove that you were raped. So we have a map here of abortion laws in the United States prior to the Roe versus Wade ruling in 1973. And you can see where the states stood on everything. Obviously down in Texas, it was illegal. Only in the case, it would only be legal in the case of if it could save the mother's life. But yeah, you can take a look at that, pause the video, and see where all the different states stood before Roe versus Wade. So she hired attorneys, but it takes a long time to go through the judicial process, especially if you're going to go into the federal court system. So by the time the case was ready to be heard, she already had the baby, and she put the baby up for adoption. To this day, it's still unclear exactly who that child is, because when you give up a child for adoption, it's supposed to be kept anonymous. So we're not really sure who that child was at the center of all this controversy. So after the birth, her attorneys brought the case through the court system. It goes into the federal courts. Even though she had the child, she wanted to pursue this issue of abortion rights. So the key question here in the Supreme Court case is, does the Constitution embrace a woman's right to terminate her pregnancy by abortion? Is there anything in there that would imply this right? Obviously, there's the big question of whose rights do we have to think about in the case of abortion? The rights of the mother or the rights of the child? Does the child have rights? At what point, if the child has rights, does it gain those? As soon as the child is conceived? Or is it when the child is born? Or is it somewhere in between during the pregnancy? So that's been the big debate of trying to find that cutoff of, does the unborn child have rights, and when can we establish that? Key questions in the abortion debate. There's a whole bunch of them. We won't read them all, but let's look at some of them. When does the life of a human being begin? At conception. When the heartbeat is detected. At viability, which most states to this day say viability. Viability means this is when a child can survive outside of the womb, which is actually during the second trimester in some cases. Is a fetus a separate being from its mother, or are all rights of the fetus given up to the mother until the birth? If the fetus has a right to life, does that take priority over the mother's right to control her own body? And there's other questions here. If you want to pause the video, you can take a look at. So once again, pro-life means you are against abortion. You support the child's rights. You do not believe any child should be aborted. Pro-choice, you support the mother's right to have an abortion, even if her health is not at issue, even if it's not a case of rape or incest. If you are pro-choice, you simply believe if a woman gets pregnant, nothing else matters, they should have the right to abort the child. So Roe versus Wade, the majority opinion here was 7-2 in favor of Jane Roe. So they ruled that the Texas law restricting abortion was unconstitutional. It violated a right to privacy that is not specifically mentioned in the Constitution, but the court has interpreted the Constitution as implying a right to privacy, which we'll get into right here. So a right to privacy, what does that mean? Well, it restrains government actions that threaten privacy of individuals. So this is implied in the 14th Amendment. The 14th Amendment strengthening protections against not only the national government, but the 14th Amendment. We talk about selective incorporation. Selective incorporation meaning those rights in the Bill of Rights also extend not only to the national government, but they also have to be provided by state governments, and we have to be protected by the actions of state governments. So when you think about this case, states had different abortion laws, and some states like Texas did not allow abortion. So was this a state government taking away that right to privacy? The Ninth Amendment, to paraphrase, the Ninth Amendment says any rights that are not specifically given, any rights or freedoms not specifically mentioned in the Constitution, or any powers not specifically given to the national government in the Constitution, are reserved to the individuals. So abortion is not mentioned in the Constitution. So would this fall under the Ninth Amendment? Would this be part of right to privacy? It's a woman's body, her ability to do what she wants with it. So you can look at, in the Roe versus Wade decision, it seems like the Ninth Amendment was coming into play, that this was a right that was reserved to the individual. So this impacted the laws of 46 different states. They had to change their laws because of this ruling, because there were only 4 states at the time that had legalized abortion, to the extent that Roe versus Wade legalized it. So this redefined the legality of abortion based on trimester guidelines. So to break it down, there's 3 trimesters in a pregnancy. During the first trimester, that's roughly 0 through 12 weeks, according to Roe versus Wade, governments, national or state, cannot prohibit abortions at all. So if a woman wants to get an abortion up through 12 weeks, the government really can't make any rules about that. They can't prohibit it. They can't say how it's going to be done. During the second trimester, which is roughly between 13 and 27 weeks into the pregnancy, governments can make some laws, but those laws are really limited to who is qualified to perform an abortion, so they can license doctors who are qualified. They can set some guidelines there. They can also say where abortions may take place, whether it's in a clinic or a hospital, but they must allow those abortions. They must allow some people to be licensed. States can't enact laws that safeguard lives of the unborn during the second trimester. They can only enact laws that would prohibit abortion if they think the abortion might be a threat to the mother's life. But according to the Roe versus Wade ruling and our interpretations of it, there's really nothing in the second trimester that can be done to protect the life of the unborn. As you can see, 20 weeks in, that looks like a baby. At this point, the fetus is developed, and this is where you really start to have to question, well, should we really be going that far beyond 20 weeks, seeing that this is obviously a human that's developed. It's not just a little embryo anymore. During the third trimester, which is roughly 28 through 40 weeks, according to Roe versus Wade and that ruling, abortions can be prohibited entirely. So this is where the states have the power to make abortion illegal. So if you really want to simplify this, during the first 2 trimesters, states must allow abortions to take place. Once the third trimester hits, that's when states can make abortion illegal. There's mandatory exceptions for cases when abortion is necessary to save the life of the mother. So if you're in one of these states where abortion is illegal during the third trimester, which most states do make abortion illegal during the third trimester, if the mother's health is at risk, states must make an exception and allow the abortion if going through the pregnancy could lead to the mother's death or serious health issues. State thresholds for abortions today. You can take a look at that. In Connecticut, we say the point of viability. So we're looking at roughly around 23 weeks would be the cutoff. And you can see how abortions have changed over the years. Since the Roe versus Wade ruling in 1973, we've seen a pretty big climb all the way into a peak in the early actually it looks like around 1990, you had 1.4 million abortions reported to the CDC that year. And it's gradually kind of come down since. And a lot of that has been about sex education and condom use and learning about this, educating younger kids, because the majority of the abortions were teenagers. So almost 46 million abortions since 1970 in the United States. That surprises a lot of people that it's that widespread. And then you have to keep in mind that California, Maryland, and New Hampshire do not report to the CDC on abortion surveillance, so these numbers are actually higher. 17 states today restrict abortion at the point of viability. So viability, once again, is that point where a child can survive outside of the womb, a fetus can survive after delivery. So this is usually considered around 23 or 24 weeks. The record is 21 weeks. So you see Lila Stenrud, I'm not sure if I'm pronouncing that correct, but she was born at 21 weeks and she survived. So Yeah, kind of makes you think maybe should 21 weeks be the guideline? If one child survived at 21 weeks, how many others who might have otherwise been aborted might have survived at 21 weeks? Current challenges to Roe versus Wade. So this really heated up last year. The state of Georgia passed something called the Heartbeat Bill. It was signed by the governor. The Heartbeat Bill makes abortions illegal as soon as the fetus's heartbeat can be detected, which the heartbeat of a fetus can be detected around 6 to 7 weeks into the pregnancy. So we're talking middle of the first trimester. So this will go against Roe versus Wade. Very controversial. There are a lot of celebrities, especially actors and actresses and production companies, who threaten to not shoot Hollywood films in the state of Georgia anymore as a sort of protest against this bill, because they viewed it as a violation of women's rights. This law was set to go into effect recently. It was supposed to go into effect January of this year, but it has been delayed by a U.S. District Court injunction. So this has already gone into the federal court system. An injunction is when a court says you have to put a temporary hold on this law. So this is still being battled, and we would assume that this will reach the Supreme Court. When we talk about it making abortions illegal, this would lead to legal charges against any doctors who would violate this law if it does go into effect. Any doctors who are found to give abortions 6 to 7 weeks after that 6 to 7 week period. And then you also have Alabama's House bill, which was passed in May of 2019, so almost a year ago. This was even more restrictive against abortions than Georgia's. So this bans abortions at every stage of pregnancy and criminalizes the procedure for doctors. So you couldn't even get an abortion up until the point of that heartbeat. They did make an exception for the case of medical emergencies if the mother's life was at risk. But this would lead to criminal penalties. This would lead to jail time, especially for doctors who would still go through with an abortion against the law. So once again, this was set to go into effect of November of 2019, but it's been delayed by a U.S. District Court injunction, just like the Georgia Heartbeat Bill. So these cases are still pending. In Georgia and Alabama, these laws are not currently in effect, even though they were passed. The court's injunction prevents them from going into effect, and these will, I'm sure, be appealed, and they will most likely, at least one of them will most likely reach the Supreme Court eventually. Just to give you some idea of public opinion over abortions, you can take a look at this. It's very clear that throughout the years, the highest percentage of Americans believe that abortion should be legal, but only under certain circumstances, which will mostly be rape, incest, or some kind of medical or life-threatening condition that would harm the mother if she went through with the pregnancy. A smaller percentage believe that abortion should be legal under any circumstances at any point, and then an even slightly smaller percentage believe that it should be illegal in all circumstances. Another way to look at this is public opinion about abortion by trimester of pregnancy. So you can see that early on in that first trimester, a majority of Americans, at least who were polled in this one, believe that abortion should be legal in the first trimester, and then you see a drastic shift. So in second, third months, in first 3 months, I think, I'm kind of wondering about this graph now. I think what this means is in the second trimester for the middle one. Yeah, I'm sorry, I was reading this graph wrong. So in the second 3 months, or between months 4 and 6 of a pregnancy, the majority of Americans believe that abortion should now be illegal. And then you see a very drastic difference here. In that final trimester, a vast majority of Americans are against allowing abortion to take place. Major religious groups have their positions on abortion. Religion plays a pretty important part. Take a look at that on your own time. Support for legal abortion has risen sharply among Democratic women. So politics play a role. Democrats are much more likely to be pro-choice. Republicans are much more likely to be pro-life. And interesting here is that Democratic women are more likely to support abortion, whereas Republican men are more likely to support abortion than Republican women. So there's this divide between Democratic women and Republican women, a very drastic divide. Very interesting today, Norma McCarvey, the one who started this all, Jane Roe, in Roe versus Wade. Well, she's had a change of heart in recent years, and she is now a pro-life advocate who is against abortion. She's the one that caused the Supreme Court case that extended abortion rights, and now she is extremely against abortion. So there's a video there. If you just want to look up the title of the video and search that on YouTube, it's really short, but you can find a lot of information out there, and even some of her speeches about why she changed her opinion in later in her life. And that's that.